Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our alternate Thursday community conference call where we discuss the issues that have been posted and, if time permits, new issues. By the way, today is going to be a day when we will not have time for new issues. I've got about 20 posted questions, and by the time we are done discussing those and the follow ups on those, the hour will be gone. Today is October 6th. We will again be meeting in 2 weeks. So, of course, you are welcome to post questions for the October 20th call. And if you go to immigration.com, I'm going to put this on the screen. You will see on the top right hand side, we have the tab that tells you where is our next community conference, when it is going to be held. So you can always post your messages following the instructions on the tab. I also want you to know that I'm following my Twitter, which is my handle is immigration.com. I'm following that. If you post something there, I'll take a look at it. I won't guarantee that I'll be able to answer it today. Today is a little busy day, but I will definitely deal with all the posted questions. Okay, that said, let's get started. As usual, I will first answer the frequently asked questions. Each time I answer a frequently asked question, I will unmute it for your follow-up questions only on that issue. Okay. Once we are done with all the frequently asked questions, then we will start working on the regular questions, which are non-frequently asked. The first question has been posted by Mohan 1983. His issues relate to changing jobs while on H1. Is there a minimum time gap necessary between jobs? Timing of resigning and joining. All these issues come up quite frequently. So let's take them in the context of the asked question. Mohanji says, Hi Rajiv, I recently moved from company A to B in July of this year as a contractor while I was on my 6th year of H1B visa. Company B has done the H1B transfer. I-140 has been approved. Now working at end client location placed to that company. Now end client wants to hire me full time. So he went from A to B. B has the I-140 approved, and the end client wants to hire him. Will jumping to company C cause any issues? And the answer is, of course not. There is no requirement that there must be a certain gap between when you went from one H1 to another. So if you moved from A to B and 10 days later decide to move from B to C, that is not illegal. The law permits you to do that. I would, of course, want you to discuss your case with your lawyers, make sure there's nothing we are missing, but as a matter of general principle, it is not forbidden for you to change companies and there is no time gap necessary. Can company B cancel my H1B? Not only can they are required to, because if they don't cancel your H1B, they are considered to be still the employer and they can be required to pay your salary. Do I have to have an approved H1B petition from company C? No, but you have to have a filed petition. This is important. So let's say company C has filed my case, then company B revoked my H1, no problem. But if before company C could file, company B revoked, I've got a problem. I would be out of status. I might have to go outside USA for visa stamping. So you have to have your second case filed before the first case is revoked. Question number 3. Will my I-140, which got approved through company B, still be valid? Yes. Yes. Can I use it for future extensions of H1B? Yes. Unlike H1, where upon you leaving the company, revocation of the H1 is required, no such requirement of revocation exists vis-a-vis or in relation to an I-140. So if company B wants to keep your I-140 in place, they can. You will have to start your green card all over again. And we have a lot of material on this. If you go to immigration.com and look at the top ribbon, I'm pointing this out on the screen, we have our frequently asked questions. If you go there, you will see all these questions have been dealt with that you have asked me because they've been asked several times before. If something is not clear, I frequently asked questions is a tremendous resource, I like to believe, because I've been building it up for years. Now, go there, see if all your questions are properly answered. If not, you're always welcome to come back. So you will have to start the green card all over again, but you should be able to use your priority date with the old I-140 approval. Company B did not provide I-140 copy. This is also a routine issue that comes up quite a bit. Folks, people who are joining us just now, bear in mind, I will not be able to take new questions today. We have enough questions on deck. And I'm also monitoring my Twitter account, also actually our Facebook account, to see if there are any questions or any, I won't be able to take new questions, but any comments that I can take. That said, going back to where we were, so how do I get a copy of my I-140? One of the ways you can get a copy of your I-140 is through a Freedom of Information Act request, which is, I think, a form G as in girl, 639. When you file a 639, it's a free, without fees form. Government then gives you a copy of your immigration paperwork. Okay. Is there any mandatory period to serve in one company when they have gotten your I-140 approval? The answer is no. There is no mandatory period that you've got to work with a company after getting your I-140 approved. All right. Any follow-up questions on these issues that I have discussed? No new questions. Press *5, please. *5 on your phone. One question. Okay. New Jersey, go ahead, please, New Jersey.
Yeah, hi. I had a question. Like, if you have this approved 140 and if you're on L1, can the new company hiring you apply for the H1 based on the approved I-140?
That's an interesting question. So you want to go from L1 to H1 and you're 6 years or 7 years on L1 or over?
No, 6 years is not over yet. So it's I'm in the second year of it, but I have an approved I-140 right now. So if I want to switch company to a new job, can the new company apply for H1 based on my approved 140?
See, there is a fundamental misunderstanding I see here about how H1s are processed. Having an I-140 is not a precondition to getting an H1 approved. So even if you didn't have an I-140 approved, you still have time left on your L1. You could have easily gone to an H1 as long as you go through the quota. Make sense?
Sorry, can you come again with that?
Okay, let me try again. So I-140 approval is not a precondition to H1 approval. You okay with that? Okay. Now you will have to go through the quota system though. They will have to apply for your H1, go through the lottery, and you'll get an H1 only if you are selected in the lottery.
Okay, but this I-140 is not a ticket to bypass the quota system.
It never is. The only reason people you see around you who are getting H1 extensions based upon the I-140 approval without worrying about the quota is because they are already on H1.
Okay. But what if my own company wants to apply for H1 based on this approved I-140? That is possible, right?
See, again, you are making that same mistake. We're back to square one. I-140 is not the basis for H1 approval.
Okay.
Quota is. You have to go through the quota.
Okay.
All right?
All right. Yeah, thank you.
You're welcome. Good luck. Okay. Folks who are just joining us right now. Oh, there's another. Ohio, you have raised your hand. I think it'll be a follow-up question. I just want to make one thing clear, guys. I won't have time for new questions today. We have a lot of questions to deal with. We won't have time for new questions. Not this time, but in the 20th October call, we'll be able to do it. Ohio, follow-up question. Go ahead, please.
Just a question on that G639 form.
Mhm.
So how long does it take to get the I-140 approval from the USCIS? The letter. My
Technically,
company is not giving me the approval.
yeah, technically, government is required to respond, I think, within 60 days, but they hardly ever do. I would say between 3 and 5 months, something like that, is my guess. Okay,
Okay,
good luck.
thank you.
You're welcome. Okay, let's go on to the next frequently asked question: errors in visa and passport. Potter P 385 says, Dad has a visitor visa on his old passport. B2 visa is expiring in 2020, so we've got still 4 years to go. He applied for Indian passport renewal and he had to correct his surname on the passport. By the way, folks, there's another question further down about name. I think there are a couple of questions about names. I think part of the problem is that our Hindi names or Telugu names or Malayali names or Tamil names, they are all spelled in English phonetically. So if my name is Rajiv, it can be spelled Rajiv, Rajeev. There's so many different permutation combinations. So often that becomes a problem when we are trying to make sure that the documents are consistent. My school leaving certificate has one, my passport has something else, my visa has something else. As a general rule, I want you to have all the names consistent, spelling as well as the names. But government is usually quite aware of these little idiosyncrasies. So I don't expect you to get into any major complications with these changes or these variations, but I think you should get them corrected wherever possible. So here, Dad has visa on the old passport, visa will expire in 4 years. Now he's getting a new Indian passport on which he's changing his name or correcting his name. So now old passport has incorrect name. B2 stamp also has incorrect name. He wants to travel to USA on B2 without going to another visa stamping. I don't think he's going to have any problem. I'll tell you why. When they correct his name, they give him his old passport back. That's the one that has the visa. Now, carrying those two passports together puts it together as the same person, I think. But if you wanted to be even more clear about this, you could try sending the consulate, US consulate in India, an email about this situation and see if they will reissue the visa. Because the problem is completely solved if they reissue, actually it's a new visa, if they'll stamp a new visa on the new passport. I would want to get this cleared up. Now let's say they don't respond or they don't want to do it. You can contact Customs and Border Protection. They are the people who check you at the airport. Explain the situation to them. Ask them what they want you to do. Once you've done these two things, report back at the conference, talk with us, and let's see where you are with this. But I do want these streamlined so they are all the same everywhere. Once again, there are some new people logging in. I want you to know, folks, I won't have time for new questions today. We are just doing the posted questions. Okay. Uh, any follow-ups on this name change on tourist visa, etc.? Press *5 on your phone. No new questions, just follow-ups on name change. Okay, nothing new. Now, Ravi Kumar also has the same issue. Namaste to you as well, Raviji. He says name spellings are different in various documents. Passport different, educational documents different. Okay. Then there is some errors in the passport also, father's surname, etc. I think wherever possible, I've said this before, you're worried about what if in the future when I do their green card, will it be a problem? I like to get these things resolved. Of course, there are ways to prove the identity of a person as your parent Mother is easy because you can just do, even father, I think, a DNA test and that's fine if you have to. But it can get complicated unnecessarily. So, whatever the corrections are, you can do that um, right now in your passport. If there's a problem with your green card name, you can very easily do a name change through the local court system. It's a very easy process in most states. And then go to Social Security and have them change your name. Go to USCIS, have them issue you a new green card. Go to Indian consulate, I don't know how they work, but they should be able to issue you a new passport as well. So get that all corrected. Especially if you have your green card already, I'm not worried about your name being different on your educational certificates. If you haven't really done your green card yet, then you do need to discuss it with your lawyers and see what they suggest. Overall, I don't think it is a very serious issue, but I think it's an irksome issue. It's an issue that can cause delays and annoyances. So try to streamline your names as far as possible. Once again, new people are logging in. We won't have time for new questions today. I can only do posted questions. Okay, anybody has a follow-up question on names, spellings, etc., press *5. No new questions, please. *5 on follow-ups on name. All right. Let's go on to the next frequently asked question. This is also a frequently asked question, quite problematic, because when you go from Canada to USA, USA to Canada, and you have your green card. By the way, Chandra, if you had your green card done by our firm, you can just call us. You don't have to post your message here. You're welcome to just call us. You have my email, just write to me. So the question is about citizenship. Because I've been traveling to and from Canada, my I-94s are not, there are no I-94s for those cases. How do I get accurate arrival departure record? In these cases, to the best of my knowledge, what we have done in the past is we just get an affidavit with an estimate from you. If you don't remember the exact dates, just get an affidavit and say these days I was out, these days I was in. Many of the people who are now listening can actually start maintaining your own logbook. And one easy thing to do is, this is what I tell people. When you cross the border, use your credit card and make a purchase in Canada, even if you buy a cup of coffee. When you come back into USA, use that credit card again to make a purchase and keep copies of those receipts. Folks, I see a lot of people logging in now. I just hate to disappoint, but I won't have time for new questions today. We are our schedule is quite booked with the posted questions. Next week, next to next week, October 20th, we'll be able to take other questions. Okay, follow-ups on I-94 from and to Canada. No new questions, please. *5 if you have a follow-up question. Okay, now this is a very, it's a recurring topic again. Liquidated damages clauses in H-1 employment contract. I have written extensively on this. If you go to immigration.com and go to the top ribbon and click on About Us, which is information about us, click on that, and then you click on the articles that I have written. Further down, it says Rajiv's articles right here. Oh, sorry. So I am actually clicking on the screen and I'm showing you in the video. So Rajiv's articles is right here. You click on my articles and you will see that I have published some articles on liquidated damages clauses in H-1 visas holders employment contracts. I also did in Los Angeles Daily Journal an opinion piece, employers, employees should beware visa abuses. This is also about liquidated damages clauses in H-1 contracts. But this article in the Practical Lawyer, this article that I published actually contains the entire law. So if you ever get sued, I would say go ahead and get your lawyers to read this article. It's a fairly lengthy article. It's a legal article. You can get them to read it. It'll help them, hopefully, defend you better. Now, let's get back to the question that we have in front of us. So my H-1B, this is Hari 777. My H-1B got applied through a company when I'm in India. But when you came here, now all of a sudden they're asking you to sign something that says if you leave the company in 12 months, you'll have to pay a bunch of things. You feel like a bonded labor. And I think that contract is actually illegal because Department of Labor considers even attorney's fees used in filing H-1s as an expense that the employer must pay. This is their usual business expense. So technically speaking, if you just mailed a copy of these two articles that I have shown you to your employer and say, look, you are disobeying the law and this is not really something you can do, hopefully they'll back off. But in this country, any fool can sue anyone. Problem is, if you get sued, what you do? You'll have to get a lawyer and you'll have to defend yourself. Can you defend yourself? You probably can if you have the time, but it becomes more complicated and difficult because you don't understand the court procedures. You have enough time, you can figure it all out. So what you should do is, if you have a new job offer, a reasonable thing to do is to talk with their lawyers, that company's lawyers. Explain to them the situation. Show them my articles, because this issue is still not quite well known. I have been talking about this for at least 4 years now, but this issue is still not well known. A lot of lawyers don't understand it. Show them my two articles, one op-ed piece, which is a summary of the problem, and then the whole article, which contains all the provisions of the law, where I'm getting my authority from. So that's good for lawyers. That's what I would recommend. You say, I'm willing to pay liquidated damages if it's reasonable. What is reasonable liquidated damages? See, liquidated damages are basically damages that are calculated ahead of time. And I don't want you to negotiate anything with your old employer. You should let lawyers of the new employer talk with the old employer. Sometimes that can turn them off too. It depends upon how much the new employer is willing to help you. My problem is sometimes the new employer could say, I don't want to get involved with all this. But it would be a good start. I don't think you can do this yourself, negotiating, etc. You should get a lawyer involved. Okay? *5 if you have a follow-up question. *5. Okay? Let's go on to the next frequently asked question. Applying for EB1 if EB2, oh, I think I have a little typo here. Don't take too much time in raising your hand, guys. You just raise your hand. I'm assuming it's for a follow-up because I'm not doing new questions today. Let's see what you've got. Okay, Illinois, go ahead, please. Illinois.
Hi, hello, Rajiv. Thank you for doing the call. So I have two short questions for you. My parents received their green card.
Okay, ma'am, I'm sorry. Hang on. I'm sorry. I don't have time for new questions today. I've been saying it many, many times, and I am only open for follow-up questions. Very sorry. 2 weeks, I will have time, but not today. Okay, so sorry, guys. I had a very, very busy morning, and we have 20 questions posted already. And that's usually I do 18, then I have a little time for follow-ups. But today we won't have time. Applying for EB1, I think I need to correct this. If EB2 when in process. Well, what I mean is if an EB2 green card is in process, can I apply for EB1? And the answer is yes, you can. Came on L1 a year back, employer applied for GC on EB2. You don't change it, you file a new case. So if an EB2 is in process or even an EB1 is in process, A second case under a different category, EB1 or EB2, can be filed, no problem at all. But just make sure that you're not saying something that's mutually inconsistent. So verify the facts so that, for example, if in EB2 you described your jobs as something different, in EB1 you're describing them as something different, that would be a big problem for you. Just make sure, as long as there's factual consistency and it's truthful, I don't see any problem in applying for an EB1 even when an EB2 is going on. Okay. *5 if you have a follow-up question. No new questions. I just noticed somebody, two people just joined in. I won't have time for new questions. I'm sorry. We are just dealing with posted questions today. 2 weeks, we will have more time. No follow-up questions. Let's go on to the next frequently asked questions. This is also an interesting question from Kumar, who's posting as PKR46. Because of health issues, I want to change my career path. I'm on H1B. I have a degree in computer science. I want to do something else. I can't work on computers. Can I do it because of health reasons? No, you cannot. There is no special exemptions because you have a health issue. You should be given a career change and H1. H1 requires you must be performing a job or will perform a job that requires a bachelor's degree in a specific field. Okay, so if you have that bachelor's degree, now, for example, let's take your case. With a degree in computer science, what are the things you could do? Well, obviously, you could work in technology. What about working as a writer? Could you work as a technical writer? Of course. If you are writing, or even reporter, if you are reporting on computer-related news, technology-related news, I think you can get an H1 based upon that. What if you became a teacher? If you are teaching computer science in high school or in college or in a training institution, could you get an H1 for that? Sure. If the job requires a degree in computer science, you can definitely do that job. So career paths have to be related to your degree if you want to get an H1. *5 if you have a follow-up question on this. I'll address the others too. *5 if you have a follow-up question on this. Okay, so your other questions was, okay, I'll get with you in 1 second. Let me just finish. Is there any way to have a break in the US while undergoing treatment? Yes. Taking time off from your job, as long as you're not getting fired, and not work for a few months as recommended by a physician is a legitimate reason not to be working. We've had a case where we converted somebody after 1 year of being out of work, but she had documentation. She was hospitalized several times. So as long as it is documented and it's medically necessary, you can take time off without falling out of status. Will I be subject to the H1B cap? Not for the next 6 years. Okay, so let me get you. This is Georgia. Go ahead with your questions, please, Georgia. Georgia?
Oh, no, yes. Hi, Rajiv.
Hello, sir.
Hi. So my question is between breaks, like, for example, I have used up all my leave with my employer. So I don't know how to take additional time off.
Okay, hang on. It is okay for you to take unpaid leave of absence.
Okay. As long as technically I am employed.
When it is medically needed and the employer is not revoking your H1, you can ask for unpaid time off. I don't think that would put your status in jeopardy, as long as you take only that much time off as you can medically justify. Okay?
Okay.
Make sense or no?
Yeah, it makes sense. But for unpaid time off, I would still have to be like employed, and they must still be okay with the status, maintain the status.
Yeah, the idea is that they are not revoking your H1. They understand somewhere along the line you'll be back, and they are okay with you taking month, 2 months, 6 months, 8 months, 10 months off for medical reasons.
Okay.
Good? All right, very good. Good luck, sir. Okay, let's go on to the next frequently asked question. I think we are running to the end of the frequently asked questions. Okay, frequently asked questions are done. Now let's go with the regular questions. Sudi M. My wife and I are Indian citizens and passport holders residing in USA on L1 and L2. Son is born in USA. We want to apply for Indian passport. I'm sorry, Sudi, I don't know how the Indian consulates work. There's nothing I can tell you here that would be helpful. This is something you will have to take up with the Indian consulate. They may have it online. They're not known for being overly helpful or overly efficient. I'm hoping that under Modi ji that has improved a little bit. But that's something you're going to have to contact the Indian consulate. I have no idea how Indian laws function anymore. Okay. Next question is hoping for best. My H1B amendment was submitted to VSC pending 2015, changed client, H1B extension in premium. So you have one pending, one submitted. First application has to get approved. Okay, this is an interesting question. So if I have one application pending for H1 transfer or amendment, can I file a second one? Yes. In order to get an approval on the second one, I have to do one of the two things. I'm giving a very generic description because there are many variations in this thing. Generically speaking, it's like a domino effect. So if you have an H1 pending, you file a second one and third one and fourth one. In order for the fourth one to get approved, all three before it either must be approved or be clearly approvable. So government can ask you to demonstrate in your number 4 application that the first 3 were approvable. What does that mean? That everything that could be required to approve those cases was in place. So you can file a second case while the first one is pending, but you do need to get with your lawyers and make sure that there is no violation of status anywhere. This can happen easily because it's a little complicated. So what happens if we request for premium processing of the old application and get RFE or denial? You'll have to go outside for visa stamping because there'll be interruption in status for approval of the second case. So if the first case gets denied before the second case is approved, you probably will have to go outside USA for visa stamp, probably, because government is not very consistent in these cases. If the old application is approved in premium, will it trigger extension application filed now to start process? No. No. I don't think that has anything to do with it. You can get both of them premiumed. How about premiuming the second one? Premium the second one, and if you want to join another client, which is another H1, you can also ask that employer to file for an H1 premium processing and be prepared to demonstrate that the first 2 cases were clearly approvable. Again, something to talk with your lawyers, not something I can discuss in the abstract. Okay. Any follow-up questions on this star 5? Okay. We've got one from New Jersey. Yes, New Jersey, please go ahead.
Yeah. Hey, hi, Rajivji. I have a question that can we file the second H1B based on an approved I-140 when one of the H1 is application is already in process?
Yes, you can. The basis for the H1 are irrelevant. Okay? You can.
Sorry, can you just come again? I didn't.
I said you can file a second application based upon an I-140 approval while the first H1 application is still pending.
Okay. And the second can also be done in premium as well, right?
Yes, it can be.
Okay.
All right.
Thanks a lot.
Good luck.
Mm-hmm.
All right. Let's go on to the next one. Hey, you guys, I know your pain. I came to this country on F1, then I went to OPT, and then I did an H1. So I understand this from both sides. Of course, my employer was super, super nice, the law firm that I worked for. Okay, next question is Prasad 121. My priority date is July 2011. Waiting for the date. Do I think the progress will be good? And there's a petition pending in White House. Look, I don't think you are going to see too many changes in priority date movement unless Congress acts on it. Because the number of applications has not decreased, the number of visas has not increased. So any lasting improvement, of course, month to month blips or quarter to quarter blips are possible, but I don't anticipate any major changes unless Congress acts. Okay. Star 5 if you have a follow-up question on this. Okay. No follow-up questions. Let's go to Sriram. Completed my master's at University X, doing PhD at the same university. Got a job offer from a company. Can I apply for OPT? See, OPT, if you want to apply based upon your master's, there's a deadline. Once that deadline is passed, what is it, 60 days after the completion of the course? After that, you can't apply. Double check with your DSO. Look also into CPT, curricular practical training. Those are the two obvious options I can think of. Of course, if the company is placing you at a quota exempt position, you could go through an exempt quota. You can also apply in April for an H1 and see if you go through, because CPT is one option. H1 without the quota is another option if you have that kind of a job, or a quota H1. These are the three obvious options. Of course, if you qualify as an extraordinary individual, you could look at O1 as well. Star 5 if you have a follow-up question. Star 5. By the way, CPT is curricular practical training. I have a blog entry on CPT. Read that. I think it's very useful. If you go to our website immigration.com and you go to Rajiv's blog on the top ribbon, you will see all the entries that we have there. They are arranged by topic on the left, and they are also arranged by date, reverse chronological order. So look at that. I have a blog entry on CPT, which is, I think, very instructive. Okay, let's go back to, I'm just checking my Twitter from time to time. Nothing new, no comments. Okay. So green 999, this is a relatively long question pattern. I'll do my best. Let me see how much I can answer. I have an I-140 with new people logging in, folks. I won't have time for new questions today. I will only be able to do follow-ups on the posted questions because we had a pretty busy schedule. So no new questions today, but we'll do it in 2 weeks. On 20th, we'll do this call. Every other Thursday, we are doing it. So I have an I-140 with the priority date 2008 with employer A in EP3. Employer B has an I-140 approved August 2015. Priority date was not ported. By the way, there isn't any formal requirement for a port. The fact that you have an I-140 approval automatically entitles you to that priority date. That can be inserted at any point of time. Now, but there is a problem that the date of birth are different on the two I-140s. That should be corrected. I think that could be problematic for you. That should be corrected. And if it cannot be corrected, your lawyers should send something in writing to USCIS that says it is the same individual, but there's an error in the date of birth. And let's see how they deal with it. It's a little bit unprecedented situation. So just go ahead and do that. I think, and you already know that you have to raise a service request. And I think you can try doing it yourself, maybe, but your lawyer, of course, can do it. Your lawyer did not make it clear that there was already an approved I-140. They did not put it in the I-140 forms. They can still submit a request. They can point out that they had made an administrative error if there's a clerical error. They should be able to get the priority date straightened out. Yes, I think so. They can still request the porting, yes. I don't know if you can correct your date of birth in the old I-140, but you can certainly try. At least to the extent where it affects you, you should be able to have an input in it. Okay, so will they inform the NVC again? You will have to do that yourself. You can't depend upon USCIS. You can hope that they will. They are under no obligation to do so, but you can take it up with the NVC. It's gonna get messy. It'll take time, but it should be done. I think it can be done. *5 if you have a follow-up question on this. No new questions. *5 for follow-ups. Okay. Wendell says, I'm in the US on B2. I applied for an MBA in Europe, but I want to enroll in MBA because I'm getting free accommodation. So can I do it? And I also have a green card pending. So normally a sibling's green card is so long away, so far away, 13, 14 years, they may or may not deal with it as a big problem. They may let it slide for a tourist visa or a student visa, I'm sorry. The fact that you got a student visa a tourist visa is also a good indication. But be mindful, there is a regulation, I don't remember the details of it, but in 8 CFR, Code of Federal Regulation, Volume 8, there is a regulation that says if somebody enters USA and they want to convert to student visa, they must declare that at the airport. If they don't, they'll have to go outside for visa stamping. Okay, so I think that regulation would be a problem for you. I don't remember the details of it. And the second thing is that sister's petition may not be a major problem. I can certainly hope so. *5 if you have a follow-up question. Okay. What are the minimum number of days needed to apply for visitor visa? See, I don't think there is a minimum there. I think if there is, it would be 6 months. But when you enter USA, your passport must be valid for at least 6 months beyond the last date of your stay. Okay, so when you renew your passport, that is the practical suggestion. 21st May 2017. That's when the passport expires. Folks who are just logging in, we won't have time for new questions. Sorry. We are just doing posted questions. They are taking up all the hour that we have today. You know what you should do? Contact the consulate. Ask them if they can renew. I'm sorry, let me take that back, not the consulate. Contact the Indian passport issuing authority, passport authority. See what is the earliest you can get an extension of the passport or the renewal of the passport. Let's talk again. Report back. Tell me what they say. But the law is 6 months beyond the dates that you intend to stay. Your passport should be valid. Okay. *5 if you have a follow-up question on this. *5. Next one from Vamsi Damera is a very odd situation. Applied for 824 for my twin daughters born in India when adjustment of status was going on. Approved now, but NVC says that they have notified the consulate. Contact consulate. What does this status actually mean? Okay, now I'm not quite certain. I've not run into this precise fact pattern before. Why have you not contacted the consulate? because I'm not sure what exactly is going on. Is it following to join? It looks like following to join because your I-824 probably said inform the consulate so they can follow to join. That might be a slightly different process. I don't know off the top of my head. Of course, I can ask somebody in the office, but not in the middle of the call. It might take a little bit longer than we have today. So, best thing to do is contact the Mumbai consulate. Ask them what you should be doing. Explain the case to them. If they don't respond, let's follow through here. In a couple of weeks, just post here again. Let's talk. *5 if you have a question. *5. Follow-up question on this. No new questions, please. Okay. No new question. Or no follow-up question. Next is brother had filed H-1B visa from March 2007. He left to India, then he came to USA on B1 visa in October. So he was gone for 4 years, I guess. He got his H-1B reinstated. Can he get 6 years of his H-1B? I think what you're asking me is something called the remainder option. I can only make a guess. Guys, I just saw 4 or 5 people just logged in. I may not have time. I don't have time for new questions. I can only do posted questions today. In 2 weeks, post your questions if you want me to take them, because that way I can be sure to answer them. But today we don't have time. No new questions. So what you're asking me is following remainder option. The idea is this. I have 6 years on my H1. I enter USA. I stay here for a year and a half. Then I leave. I'm outside USA for more than a year. At that point, if I want to apply for an H1, I have a choice. Because I have been outside USA for a year or more, I can take 6 years of H1 again, but I'll be subject to the quota. Okay. The other way I can approach this is I can say I don't want to be subject to the quota. Give me an H1 for the time that is remaining. So I was in USA for a year and a half. I will accept a total of 4.5 years left. But I don't want to be subject to the quota. That's called remainder option. But you can't have it both ways. You can't exercise remainder option and then say, give me 6 years. It doesn't work like that. I think that's what you're asking me. *5, if you have a question on this, *5. Folks, once again, I'm reminding you, I don't have time for new questions. Not today. Okay. Next question is, I'm on my 7th year of H-1B with company A. I-140 approved. Priority date is 2014. Company B has an H-1 approval also. If company A revokes my I-140, can I still port the priority date? And the answer is yes. Go to my blog, and we have talked about this issue. The current reading of the government is that you can keep the priority date. Only in 2 circumstances they'll take it away. 1, if they approve the I-140 in error, or 2, if USCIS revokes the I-140 for fraud or misrepresentation. Okay. My wife is on H-4EAD. If company A revokes I-140, what happens to the EAD? I have discussed this in detail as well. It's on my blog and also in our frequently asked questions. And all of that is from the top panel of immigration.com. We have links to all of that. So the USCIS thinking on this was this. If H-4EAD is approved, then I-140 is revoked. They reserve the right to cancel the H-4EAD. But will they do it? So far, it doesn't look like they've been doing it, but they certainly can. So now with the new H-1B approval, can I apply for her H-4 extension and EAD? As long as the I-140 is pending. Let me rephrase that. As long as the I-140 has not been revoked, you can get her EAD and of course the H-4 extension. Fourth question. I saw that USCIS has recently updated that you can file your 485 within 5-6 years. No, no, no. They have slightly changed the procedure, but it's not going to give you a guarantee of being able to file your green card within 5 or 6 years. No, that is not true. They might have made it a little earlier in some cases to file a 485, but they don't do that every month. It is a month-to-month determination. Okay, that pretty much answers your questions. Star 5 if you have a follow-up question on this. Star 5, please. Next question is about adoption. This is a very, very focused question where if somebody has been adopted here, not outside USA, can we still undergo adoption? I'm sorry, this is something I would have to research. I don't know the answer off the top of my head. It seems reasonable to argue that custody is the important thing. Whether the custody was outside USA or inside USA should be completely irrelevant. That would be my argument, but I haven't looked at the law, so don't take my word for it. I would suggest you get yourself a lawyer, let them research this issue. You can do it another way. You can contact your congressman. They might be able to, and they should be able to find you this information free of charge from the US government. And usually the information they get you is pretty reliable. Okay, as long as you describe your situation properly. Star 5 if you have a follow-up question on this. Star 5. Okay, there was another posted question about names. My parents use different surnames and I use a different surname. This is also common in India. Due to different surnames, I'm planning to take different appointment for my mother and my brother's family. I don't think that's necessary. I think you should. I don't like to play these cute little games with the government. I do it all by the book. The fact is that the surnames are different, and that by itself shouldn't be damaging to your case. Okay. So what you will need to do to correct that situation, let's get to that situation and see what happens. When they go for visitor visa, let's see if government even makes an issue of it. They may not, because there will be so much evidence that DNA is one evidence. I mean, if necessary, although DNA usually we do it in the context of a green card, not just a tourist visa. You also will have pictures together, functions together. Your school leaving certificates will have their names. So things like that, I don't think this is going to be a major issue, personally. I would like it, but here it's not a problem within the same person's history. It's a problem, part of the family has one last name, part of the family has another. I think you'll be okay. Go apply for their tourist visa, see what happens. And I don't have any suggestions for where you can go for sample questions for tourist visa. I think each situation is different. They can ask you pretty much anything. Star 5 if there's a follow-up question. Okay, so this brings me to my last question for the day, and I do apologize. We don't have time for new questions today, but I did tweet about it. I sent out a tweet that we won't have time for new questions. I-485 can be filed. This is posted by Monica, our administrator. 485 can be filed on previous company approved I-140. My I-140 is approved with company A. Company B is planning to buy out my services from company A. Company A will not revoke my I-140. They'll give it in writing. If everything goes fine, then I will join company B full-time. They'll transfer my H-1B and file my green card from start. Question number 1. Before my new I-140 gets approved, can I file 485 with old approved I-140? And the answer is no, unless you intend to join the company who sponsored the I-140. So if you want to go back and join company A, and that is your intention, upon approval of the green card, you can file the I-140. But if I were USCIS, I would want to know if your intention was to join company A, why did you leave? If you have a good answer for that, sure. Truthful, of course. Can you please suggest all precautions my new attorney needs to take so I can retain my old priority date? Get a lawyer who knows what they're doing. That would be my suggestion. But priority date transfer by itself is not a problem. That's a right that you have. It doesn't require any large effort on the part of the lawyers. Transfer of priority date is an automatic right. Okay, any follow-up question on this star 5? This will be the last question of the day, folks. Any follow-up question? Star 5? Okay, very good. We will talk again in 2 weeks on October 20th. Please post your questions ahead of time. I can then guarantee that I will deal with them. But unposted questions, sometimes I don't have time to answer. Thank you all for being here. I always enjoy talking with you, and I appreciate the opportunity to be of service. Take care, folks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.